Hey, we will go on the record. It is 10 a.m. on July 20th. This is the hearing for appeal number 186-23250 PLNG, which is an appeal by Robert Strickland relating to the county's approval of a validation of a unit of land in file number 186-22638 PLNG. My name is Tommy Brooks. I am the hearings officer presiding over this matter. Before we begin, I'm going to say a few words about the format of the hearing. We are conducting this hearing using audio and video conferencing with participants each appearing from different locations. We're going to still follow the normal hearing procedures, and I will provide sufficient opportunity for everyone to participate at the appropriate time. You will be called on individually to begin your comments. I'd ask that you mute your line until you are called on and do not begin speaking until you are called. Before you begin your comments, please state your name and address for the record. My role as the hearings officer is to affirm or deny the appeal. We are conducting the hearing as a de novo hearing, meaning that participants are allowed to provide new facts and arguments during your live testimony. If you have written comments, please provide those to staff before the close of the record so that they can be included. In rendering my decision, I'm going to consider only the factual evidence that is in the record. I will then apply those facts to the applicable criteria that are contained in the county's comprehensive plan and land use regulations. And the applicable criteria were identified in the public notice announcing the hearing. They're also set forth in the decision that was appealed. Those documents are posted on the county's website and available upon request. It is important that you direct all of your testimony only to the applicable criteria. If you believe a criterion applies that was not listed, you may address the unlisted criterion. However, I urge you to explain why the criterion must apply so that others can respond and so that I can address that criterion in my decision. Failure to raise an issue with enough detail that enables me or other participants to respond precludes your ability to appeal that issue to the Land Use Board of Appeals. Also, the failure to raise a constitutional or other issue relating to any proposed condition of approval, again, with enough detail that allows me to respond to that issue in my decision, precludes an action for damages in circuit court. As I just noted, I serve as the county's hearings officer. While I have a contract with the county to serve in that role, I am obligated to remain impartial. So to that end, I'll go on the record to state that I do not know the applicants or any other participants. I have not visited the site, and I also have no ex parte contacts to disclose. The hearing will be conducted in an order that I'll give. I don't anticipate setting time limits for anyone's participation given the relatively few number of participants, but I do reserve the right to impose time limits, and especially if the testimony is veering away from the applicable criteria. The order of the hearing is going to be that we'll ask staff to go first to present the staff report. The applicant can then present the application. Those in favor of the application, other than the applicant, would then follow, followed by anyone opposed to the application. The applicant who bears the burden of proof is going to be given an opportunity to give a rebuttal. And then we might conclude with either staff comments or questions if I have any of the staff. So before we begin, does anyone wish to challenge my ability to hear this matter or to challenge the county's jurisdiction over this matter?
No, my attorney just texted me, said he's waiting to be let into the Zoom meeting.
I'm here.
Oh, you're there? Okay, there you are. All right. Sounds good.
All right, so hearing no objections, we will begin and we'll start with the staff report. Is that going to be you, David? Or is it
Actually, we're going to have a couple of staff people present.
Great.
I'm Julia Decker, Julia, D as in Denver, Ecker, Planning Manager, Community Development. I will also be asking David Cook, our planner, to present part of this, and we may also request Adam Niles to make a brief statement. Staff is going to start with talking about the lot of record determination that was done in May of 2022, which is kind of what landed this whole thing. In May of 2022, Ryan Osburn and Melanie Bassett requested a lot of record determination prior to some other application that they wanted to do with the property known, we'll just call it tax lot 400. It is Township 7 North, Range 10 West, Section 10, tax lot 400, and it is more or less 168 acres, and it is split zoned EFU, which is exclusive farm use, and F80, forestry, 80 acre minimum. Both of those are resource zones. It is contiguous with some other tax lots, including one owned by Mr. Strickland, which is tax lot 1700. There are some other zones involved as well, but these are the ones that, for the purposes of this morning, matter the most. We have the definition of a lot of record, which is any lot or parcel lawfully created by a subdivision or partition plat of record in the county clerk's office, or lawfully created by deed or land sales contract prior to partitioning requirements of the records in deeds of Clatsop County. So in doing the lot of record determination on tax lot 400, staff found that it was originally created in 1951 by a deed recorded conveying it from the Hardesties to Mr. Strickland's parents, Curtis and Christine. And so that was created 1951, and it met the definition of a lot of record. And after that time, there was litigation, and a number of things happened to the property that changed its size and configuration using methods that were not approved for land use purposes, which I'll describe in a moment. Anyway, it created a violation, and staff found that it appeared we could cure the violation using ORS 92.176 or by completing a property line adjustment, which would also resolve the issue on tax lot 1700. But at any rate, we did find that tax lot 400 was not currently in compliance and was considered not a parcel. It is not a legal buildable lot of record or parcel using the county's definition. So staff found that both 400 and 1700 were originally created by deeds prior to September 30th, 1980, which established the applicable planning, zoning, and partitioning ordinances and regulations. And then due to the subsequent adjustments and everything that happened after that, they fell out of compliance. Now we have general exceptions to lot standards. And so in doing the lot of record determination, staff ended up applying Law Duck, Land and Water Development and Use Code, section 1.1020, general exception to lot size standards. And in that, it says, if at the time the applicable zone or an amendment to the applicable lot size or dimension standards was adopted, a lot of record has an area or dimension that does not meet the requirements of the zone, and the lot of record was not in the same ownership with contiguous lot or parcel, which does not meet the minimum lot size or dimension requirements, the lot may be developed as allowed by the applicable zone and county development standards. One thing staff found was this parcel far exceeds the 80 acre minimum lot size. So subsequent to litigation, tax lot 400 passed into the ownership of William A. Strickland, and this is all found in the staff report for the lot of record determination, which is part of the exhibits for the legalization. So I'm thinking, let's see, basically what we found was tax lot 400 was subject to litigation beginning in the mid to late 1980s. Christine Strickland sought to have a 1981 deed rescinded. After several years of trying, the family was unable to reach an accord on management agreement for the property. And in the judgment for case number CC 85-2003, which was from 1985, it was Clatsop County Circuit Court, which was filed on July 27th, 1994, Clatsop County Circuit Court Judge Edison ordered the property described, which was tax lot 400, described at book 567, page 816, to be divided using a boundary line adjustment procedure. He used the term partition, but what he required of Mr. Strickland was to use a boundary line adjustment procedure with tax lot 1700 in Mr. Strickland's ownership immediately to the south. Mr. Strickland appealed this through various courts, and it just sort of stalled out at some point, and finally the appeals court remanded for consideration a cross claim for the partition back in 1989. Anyway, the Court of Appeals decision is included in the documents, and litigation continued. After Christine Strickland's death in August 18th, 2004, judgment for case number CC 85-2005, which is Exhibit G, finally was recorded with the Clatsop County Clerk on December 21st, 2004, where it is now identified as instrument number 2004-15085. Assessor records indicate a voucher for the segregation was completed on August 29th, 2006, with an effective date of July 27th, 1994, which is the date the judgment was filed in circuit court. Then in 2007, some other things happened with LUBA, but basically this is where we are now with it. So in 2006, the segregation was completed by the Clatsop County cartographer in the Department of Assessment and Taxation. That would be by Mr. Niles' predecessor, which shifted the tax lot line to the location stipulated by Judge Edison in case number CC 85-2005. However, a segregation is not the same as a boundary line adjustment. A land use procedure that uses specific standards and requires specific reviews and approvals by the county's community development department and the county surveyor. A segregation merely moves, adds, or removes lines on paper without changing the underlying boundaries. It generally is done for taxing purposes, but it is not a legal partition. It is not a legal property line adjustment. So without going through the appropriate boundary line adjustment procedure, the tax lot boundaries for 400 and 1700 are not changed for land use purposes, which was part of the LUBA decision from 2006. So for land use purposes, tax lot 400 remains in the same configuration as when Christine Strickland conveyed it to William A. Strickland and Robert C. Strickland via the deed recorded at book 567, page 816 in the Clatsop County Book of Deed Records on December 2nd, 1981. Tax lot 400 currently, it's tax lot, not a parcel, currently is in the Osburn Bassett ownership, according to the way the community development is required by ordinance to consider ownership. And tax lot 1700 remains in Mr. Strickland's ownership. So the segregation does not fulfill the judgment, and it does not fulfill land use regulations. So with that in mind, that is how we sort of got here today. One thing I wanted to do was make sure that we had a couple of definitions clearly in mind. Let me shuffle some paper very quickly for you. So according to Land and Water Development and Use Code, section 1.0500, an owner of record or real property as shown on the tax rolls of the county, or a person who is purchasing a piece of property under contract. That is what the county's community development department is required to use. That is for ownership, and that is what this department used when doing the lot of record determination. This is what we were presented with. And staff does not use the GIS to determine that. Staff actually looks the records up in the assessor's office and the clerk's office. One thing I also wanted to note is the definition of resource zones. The following zones shall be considered resource zones. That includes EFU, which is exclusive farm use, AF, which is agriculture forestry, F80, which is forestry with the 80-acre minimum, OPR, parks or open space parks and recreation, and LW, which is lake and wetlands, and that encompasses the zoning of both of these parcels. So I think at that point, this staff person will rest and ask Mr. Cook to discuss his section.
Thank you.
Thank you, Julia. I'm David Cook, Clatsop County Community Development Planner. I was the primary staff person working on the follow-up application submitted by Mr. Osborne and Ms. Bassett. As Julie kind of explained, based on the lot of record determining that the unit of land, the subject unit of land, tax lot 400, was not a lot of record, as it was not lawfully created. Ryan Osburn and Melanie Bassett submitted an application to validate the unit of land. Oregon Revised Statute 92.176 provides an avenue for this, and the local application we used here at the county was a major partition application, and we applied the standards described in ORS 92.176 as well as the local standards for a major partition to the application. As the staff report describes, this is attachment A or exhibit A of the staff cover memo that was sent out about 8 days ago. As that staff report describes, the standards of ORS 92.176 and the county's standards for a major partition were met by the application submitted by Mr. Osborne and Ms. Bassett. On May 18th, 2023, based on that staff report, staff issued a conditional approval validating that unit of land. On May 30th, 2023, the appellant, Mr. Robert Strickland, filed an appeal of the director's decision approving with conditions that validation of a unit of land. And the grounds for that appeal are stated on page 2 of the staff cover memo that, again, was sent out about 8 days ago. That kind of brings us up to where we are now. I'm happy to answer any questions if there are particulars in the staff report or the staff cover memo that anybody has a question on.
Right. Not at this time, I think.
This is Julia. Really quickly, I would like to ask if Mr. Niles can briefly describe the materials that he provided to Mr. Strickland, just to describe what they are, so that we understand the map.
Yeah, I think I sent him 4 different maps.
And
one
Adam,
was,
we can't hear you.
You can't hear me? Can you hear me now?
I can actually hear you quite well.
Okay.
Julia, I don't know.
I'll talk a little bit louder. I'm using a laptop. So I provided Mr. Strickland with 4 different tax maps. One was last updated in probably 1998, 1999. That had the original configuration of the tax lots. And then another map from 2017 was the next available map that I had available. And that showed the dividing line for tax lot purposes between the north and south, based on the legal description in the court order. The other 2 maps, one was from 2021, and then the current one. There weren't any changes on those maps. We had different GIS software. So I just kind of wanted to explain that the only changes to the tax lots from 2017 to now were just cosmetic changes. There were no boundary changes at all. I can take any questions if there are any. I
have no questions for staff at the moment. I appreciate sort of the linear walkthrough of everything, but so far the tracks with what I was seeing in the record. So I think we'll, unless there's other information from staff, we can move on to the applicant.
Good morning. My name is Josh Stellman from Hagman Kelly LLP, and I represent applicants in this appeal proceeding. And the applicants, I may have my clients add any additional information they wish to, but for right now, the gist of applicant's position is that the staff report is spot on. And the appeal and the various arguments about this validation application are based on essentially trying to get another bite at the apple at long ago settled fights and settled battles over what's going on and what happened with this land. In a 2007 land use LUBA decision, it notes, it goes through even more succinctly the case law and kind of the legal proceedings related to this land, and particularly noted is that the petitioner, Mr. Strickland, he originally challenged the 1994 Circuit Court stipulated judgment of partition. The Court of Appeals affirmed. He challenged the validity of the stipulated judgment in 1999. The Circuit Court here dismissed on summary judgment, and it was affirmed without opinion in 2001. So the ownership of this property should not be in doubt, and to the extent the appellants are attempting to challenge that here, it's not the appropriate place. The ownership is set forth and established in the very, very well documented and presented staff report, and to the extent that everyone agrees this is not a valid or a legal unit of land, that's why we're here, and that's why 92.176 exists. And this is the opportunity to do that. There were arguments or statements made regarding the interplay between a validation of unit of land and a partition, and that's been incorporated into the statute and the staff conditions requiring that a final partition plat be established within 365 days of the validation of unit land application being granted. So there certainly could be more in rebuttal based on the statements that are made by the various parties, but for now, reiterate that the applicants believe that the staff report, again, is well presented, well documented, and does a great job of really explaining and clearly establishing what is definitely a confusing history and current application.
Okay, thank you, Mr. Stellman. Do you anticipate one of the applicants will also be speaking, or is that it for the applicant's presentation?
We'll check and see. Ryan, would you like to say anything? You're on mute.
No, I think I may let Josh kind of run with it here. The only thing I might add is I've had two title companies do a lot of determination, and they all came back in our name. That's probably all I have to add at this time.
Hey, thank you. Staff, do we have anybody that's signed up to or has identified themselves to speak in favor of the application other than the applicant?
Oh, we do not.
Okay. So then we can move on to those who are opposed to the application, and I will begin with the appellant, Mr. Strickland.
Good morning.
Good morning.
Is this the time for me to read my text there?
Yes, if you could identify yourself for the record, and then this is your time to give all your testimony that you want to have entered into the record.
My name is Robert C. Strickland, Strickline, 90603 Highway 101, Warrenton, Oregon, 97146-7251. The subject property of today's hearing is part of what commonly has been known as Strickland Farm for over 70 years. Since my parents, Curtis and Christine Strickland, bought the heart of it in January 1950. I am, and since 1981, have remained a 50% co-tenant of the subject property in this application. Since 1981, I have been a 50% co-tenant in the entire Strickland Farm as it was delineated as a lot of record, i.e. contiguous property under common ownership owned by Curtis and Christine Strickland before his death on 24 September 1974, and by my mother Christine alone till late 1981. I have never sold any part of my co-tenancy interest to the applicants or to any other entity. In addition to my 50% co-tenancy in the subject area of today's hearing, I own a 100% fee simple interest in certain other areas within the delineated boundaries of the southern segment of the split tax account. The farm never has been partitioned. In 2006, the Department of Assessment and Taxation changed the tax map to split the farm tax account into north and south parts. This amendment of the tax map did not create additional parcels. The definition of parcel specifically excludes a unit of land created solely to establish a separate tax account. The county testified before the Land Use Board of Appeals in cases 2006-208 and 2006-231 that no land use action, such as a partition, had occurred as a result of the tax map alteration. No partition ever occurred at a following date. Judge Thomas E. Edison ordered a partition on July 27, 1994, but his order was not in compliance with land use laws, and by statute, it could not be put into effect. Statutes trump case law. In 1978, the Oregon legislature eliminated the judicial exception, so that following that date to be effective, even judges' orders had to comply with all land use laws concerning partition, including the 80-acre minimum parcel size for all resultant parcels involved in partition of EFU zoned lands and F80 zoned lands. An article on the Oregon State Bar website entitled "Breaking Up is Hard to Do, Peculiar Attempts to Partition" discusses the Oregon Attorney General's March 16, 1978, opinion number 7587, to the effect that there is no statutory basis for a non-compliant judicial partition. 38 OR OOP, Attorney General 1814, 1978, WL 29473, ORAG, link to the bar document, http www.osbar.org, docs sections. Anyway, it is listed in the material there, but there is a link directly to that article regarding the Oregon Attorney General's 1978 opinion. Strickland Farm includes 4 distinct land use zones: EFU, F80, LW, Lake and Wetland, and OPR. open space, parks, and recreation. It's mathematically impossible for a partition to have been devised that complied with the EFU and F80 resultant parcels and minimum sizes. Neither the northern or southern area in the county's tax lot amendment resulted in parcels with 80 acres of EFU. The delineated southern sector did not result in inclusion of 80 acres of F80. Today's matter also involves a second level unlawful attempt to partition. The deed dated 27 August 2021, instrument 202-108-877 from John R. Strickland et al. To Ryan Osburn and Melanie June Bassett, that separated tax lot 710-10-000-1600 on assessor's records from tax lot 710-10-000-400 could not have been lawful. Tax lot 710-10-000-1600 is an EFU zoned parcel 2.0 acres in size, far below the 80-acre required minimum size for either resultant parcel in a transaction that divides exclusive farm use property. An unlawful division of land creates two unlawful units of land rather than an unlawful unit of land and a lawful remainder. Land Watch, Lane County versus Lane County, 80 OR LUBA 415, 2019. The county recorder records whatever documents are presented to her in proper statutory form without purporting to determine the validity of the transaction she records. Assessment and Taxation asserts it does not have the authority to decide whether a deed is lawful or not. If a deed has been recorded in a manner that meets statutory requirements, Assessment and Taxation updates its records accordingly, regardless of any invalidity of the transaction. The county at LUBA in 2005 asserted that no land use action, such as a partition or creation of a unit of land, occurred when the county divided the Strickland Farm tax account into north and south areas. If there were any question about that, this should clarify that the county cannot validate a unit of land created during the past 16 years. Oregon Public Law Statutes, ORS 92.176. A county or city may not approve an application to validate a unit of land under this section if the unit of land were unlawfully created on or after January 1st, 2007. There is a statutory remedy for persons in Ryan's and Melanie's situation. Per ORS 92.018, buyer's remedies for purchase of improperly created unit of land. If a person buys a unit of land that is not a lawfully established unit of land, the person may bring an individual action against the seller in an appropriate court to recover damages or to obtain equitable relief. The court shall award reasonable attorney's fees to the prevailing party in action under this section. See Oregon Legislature.gov bills ORS 092.html. Applicants Osburn and Bassett are not full owners of the subject property in today's hearing, and therefore they do not have authority to execute a partition of it. The county may argue otherwise, but people can't buy what can't be sold. And at the time, Osburn and Bassett thought they were scooping an off-market property from enthusiastic sellers. The property in the transaction was not a lawfully created lot of record. Thank you.
Thank you, Mr. Strickland. I do have a few questions for you, just so I can make sure I understand the particulars of your argument. and I'll start one. You made reference to like a 2-acre parcel that was also transferred. Can you describe that to me in more detail and how that relates to tax lot 400?
When I recently looked at the county web maps, it would show John Strickland, who is my nephew, owning a 2.0 tax lot 1600 adjacent to the tax lot 400 of Ryan and Melanie. It just, when you pull it up on the county web maps, it shows that it's EFU 2.0 acre. And this appeared following the August 2019 or 2021 deed. That's referenced above. So if I were to look there now, I would expect to see that. Okay, now home in on 1600. Okay, and then click on the information about it. Yeah.
Okay.
Anyway, yes, that's 1600, and that was a resultant part of this transaction, the sale to August 2021 to Ryan and Melanie. So it effectively separated those two pieces. This was a resultant parcel that was only 2 acres of EFU land. And fundamental to Oregon land use laws, you don't chop up farm and forest land. And where the resultant parcels are less than 80 acres, either of EFU or of F80.
Okay, thank you for clarifying that. I now see you're referring to tax lot 1600, so that is helpful. The follow-up question I have for you, just sort of, I want to understand kind of the main foundation of your ownership argument. Are you arguing now that your, let's say, that the court order that basically transferred ownership or divided ownership, the stipulation and the judgment that came along with that, and that dates back to 1994, and I realized that it wasn't recorded until much later, but that judgment itself is unlawful, or are you saying that the judgment actually doesn't do what the county says it does?
That doesn't ordered something that couldn't be accomplished. Basically because the legislature eliminated his power to do that.
Okay.
And he basically felt that he was the law and he could do anything he damn well pleased, but that was ignoring that the legislature eliminated the judicial exception in 1978.
Okay. Thank you for clarifying. I just wanted to make sure I understood your position that it was the judgment itself. Okay. Mr. Strickland, I think that's all the questions I have for you. Thank you.
Thank you.
Is there anyone else who has signed up in opposition to the application? Doesn't sound like it.
Yeah, Mr. Brooks' staff isn't aware of any other participants willing to speak in opposition.
Okay, thank you. So that will bring us back then to the applicant, if the applicant would like to offer some rebuttal.
Just briefly, to really narrow down the gist of our response to Mr. Strickland's argument, his position is an ownership question. Every one of his arguments and oppositions to this application are based on what he believes is an incorrect ownership decision. But the fact remains that this was established in 1994. There was an appeal. That appeal was affirmed. There were multiple other lawsuits, including a land use decision, that in which Mr. Strickland attempted to invalidate that decision, but that decision stands. The ownership is established, and regardless, this is not the staff report has given its conclusion as to why the land is or why the ownership of the land is solid for purposes of this application. And given the prior legal history and the legal judgments as to ownership, the hearings officer, and no one has in this setting has the authority to overrule those decisions. If Mr. Strickland has additional issues with this, those can be brought up further along the line within the context of the validation and this validation, and also the partition, the eventual partition hearing. I will make note that I do believe that from my perspective, that the 1994 decision, but the judge's decision raised some confusing issues when he did say partitioned. When he noted it was partitioned. Well, that lawsuit was brought under ORS 105.205, which is called a partition suit. And so the language could have been different, but that doesn't invalidate, that semantic issue does not invalidate the ultimate determination that the judge made, that was appealed, that was affirmed. That's all for applicant.
Thank you, Mr. Summit. I do have one follow-up question for you, though. Is there any relevance to this tax lot 1600 issue that was raised?
None from our perspective.
Okay. All right. Thank you. So we can conclude the rebuttal, it sounds like, I do have a follow-up question for staff. Just to be clear, if staff provides any information that requires additional rebuttal from the applicant, I will certainly allow that. The applicant bears the burden of proof, and so I'll let you go last. But Ms. Decker, I think the question's for you because it relates to maybe the lot legality issue, but do you see any relevance to the tax lot 1600 issue that was raised?
Thank you. Staff took a look at tax lot 1600, which, as you can see, is not actually contiguous with 400, but it is contiguous with another property that is 2500 and 2503 that are substandard in size and still in the EFU zone. Tax lot 1600 was created, was created by book 341, page 97, Clatsop County Book of Deed Records on November 19th, 1970. And staff has a copy of the original deed from the deed records, conveying it to Curtis and Christine Strickland, and the meets and bounds are identical to the meets and bounds of it when Mr. Osburn and Ms. Bassett conveyed it back to John Strickland. So staff already found earlier this morning that tax lot 1600 is on its own a parcel. It is a legal parcel on its own. It was legally created. It remains in the exact same configuration. There may have been some cancel and combining up in the tax office for tax purposes, but it never changed the underlying issue of this is a legally created parcel separate from tax lot 400, separate from tax lot 1700. And if we look at the definition of and exclusions from the minimum parcel size, we're going to find that a lot of record was not in this, that is not in the same ownership with a contiguous lot or parcel which does not meet the minimum area or dimension requirements. The lot may be developed as allowable. All of these other tax lots, the 400 and 1700, these are all in excess of 80 acres. So tax lot 1600 stands alone.
All right. Thank you for that clarification from staff. I don't have any other questions for staff. And since unless the app, I don't want to put words in the applicant's mouth, but I don't think anything would require rebuttal from what staff said, unless you unless you disagree with something that staff said.
No.
Okay.
I do.
Sorry, Mr. Strickland. This is really the time for rebuttal right now. You've raised the issue, and the other parties are allowed to respond to it, and I'm not going to allow what I'd call sir rebuttal. So we're gonna conclude that discussion. So with that, are there any procedural issues that need to be raised before we go off the record? And this is directed at staff.
Staff is not aware of any.
Okay. All right, well, with that, then we will close the record. I'll take this issue under advisement and issue a written decision, and then we'll conclude the hearing today and the record, and we'll go off the record. It's 10:46 a.m. Thank you, everyone.
Thank you.